Hello, my name is Deputy First Assistant Prosecutor Mario Formica from the Atlanta County Prosecutor's Office. And New Jersey, like many other states, has adopted what is known as the red flag law. It permits family members and police officers to seek emergent orders for a person who poses a danger to himself or others because of a mental health crisis, as well as an intoxication or a drug use crisis. For police officers, prosecutors, and the courts, such an order is known as a temporary extreme risk protection order. And that order gives the police the right at least to temporarily take possession of firearms. In a nutshell, the law allows a family member or a police officer to petition the court for an order to remove firearms most of the time from a residence if it can be shown under a standard of probable cause. That's not a standard of absolute certainty or even beyond a reasonable doubt, that the person does in fact possess a firearm, that the person can gain access to a firearm, and that the person poses an immediate threat to himself or others. Now, taking a gun away from a person is kind of a big deal because our U.S. Constitution gives citizens the right to bear arms, and in the absence of a person having a criminal record or a mental disorder, every person has the right to keep a firearm in their home. That's a constitutional underpinning, the same as the right to vote, the right to effective counsel, and the right to be free from unreasonable search and seizures, which is a nice segue to how the process of a temporary extreme risk protection order flows. To start the process, a petition and an affidavit must allege, based upon the affiant's personal knowledge, that a firearm is present in a certain place. Most of the time, again, it's a private residence. There is a person who can gain access to that firearm, and that person poses an immediate threat to himself or others. All of this is presented to the court ex parte, as they say, meaning without the other person's knowledge or the right to consent. When the judge receives and reviews the petition, he or she must then consider 8 primary factors that the law has laid out. Number 1, does the person have a history of violence? Number 2, does the person have a history of any physical force against another person? Number 3, is the person subject to any domestic violence restraining order or has violated a domestic violence restraining order? Number 4, is the person subject to any sexual assault restraining order or has that person violated such an order? Number 5, does the person have any prior arrest charges for a violent crime or a disorderly persons offense? Number 6, does the person have any arrests or pending charges for cruelty against animals? Number 7, does the person have a history of drug or alcohol abuse? And number 8, has the person recently received a firearm? The law then requires the court to consider 3 additional factors, those being: number 1, has the person recklessly displayed the firearm? Number 2, was there a previous temporary extreme risk protection order lodged against the person? And number 3, has the person previously violated such an order? The law also says that these 11 factors are not exclusive, and the court can consider any other relevant evidence that the police officer or the family member presents to the court. If the court finds at least one of those 11 factors, it may consider 4 other factors that ask whether the person has been previously receiving mental health treatment, has that person ever been committed, has that person ever failed to comply with mental health recommendations, or has the person received a mental health disorder diagnosis. Despite the fact that all of this may sound a bit technical, from my perspective, the red flag law is really well intended and seeks to balance an individual's constitutional right to possess a firearm against a real and immediate need to prevent a tragedy, which unfortunately we keep seeing in the media almost every week. Okay, so if a family member finds himself or herself seeking a temporary extreme risk protection order for a family member or a friend who is having a mental health crisis or is abusing alcohol or drugs, what should she do? Well, number 1, I'd say simply call the police. They will come, they will address the situation immediately, which generally leads the person in danger to be taken to a mental health crisis facility or a hospital. The police, if they're on the scene, will also then have the opportunity to either have the gun turned over to them by the person or if that's not possible, to gather information independently through their investigation on the scene. Most likely then they call the prosecutor's office for assistance. The officer will prepare an affidavit and a petition for a temporary extreme risk protection order, and if necessary, a search warrant for the gun or guns that may be in the residence. Now, as stated previously, after presenting the petition and the affidavit to a judge, and by the way, this could be a municipal court judge or a superior court judge, the judge will then follow and consider the list of statutory factors that I talked about, and then make a decision to issue an order or not, again, based upon probable cause, not an absolute certainty, that one, the person owns or possesses a firearm or ammunition. Number two, the person can gain access to that firearm. And number three, the person poses an immediate threat to himself or others. Now, as I alluded to earlier, along with the order, the judge may issue a search warrant if the firearm cannot be located on the scene by the police and the family member does not have the ability to consent. Now, what does that mean? Well, a little constitutional law. Let's say the concerned family member is a brother, who we'll call John, who calls about his brother in a mental health crisis, who lives in an apartment by himself, and we'll call him Bob. If Bob's in crisis, he probably can't knowingly and intelligently consent to a search of his house. And if John doesn't live with Bob, he doesn't have the authority to give police to consent to search his brother's home. So the judge, based upon those facts in the affidavit, can issue a search warrant for Bob's house to find the guns that may be in there. And just for the purpose of completeness, if the judge issues a temporary extreme risk protection order, the cops go in and get the gun, Bob goes to the hospital, is released, comes home. Those guns cannot be returned to him until what is known as a final extreme risk protection order hearing takes place. In that hearing, Bob can come in with or without a lawyer, can present any evidence he wants showing he's all better, and the state, meaning the prosecutor, can present evidence that he's not okay, and the court needs to enter a final extreme risk protection order. But the standard is higher, as you can imagine, to issue a final order, taking a gun away from somebody permanently, and that is the judge has to find that there is a preponderance of evidence that Bob still poses a significant danger of bodily injury to others. A number of important documents are attached to this link. As you'll see, you can access them, and that's about it. With me is Lieutenant Michael Finan of the Brigantine Police Department, and Lieutenant Finan, for the benefit of our viewers, you and I actually worked on a temporary extreme risk protection order. Could you explain how the process unfolds once you're called to the scene?
So once you're called to the scene, the first thing obviously is scene safety. You have to protect yourself and your guys. Going to a call like this to where a concerned resident or family member feels like that this person may pose a risk to anyone. So scene safety is first. You have to protect yourself. But upon arrival to the scene like this, you have to assess all the situations from the complainant itself, the caller, as well as the accused, and find out exactly what statements were made or what threats might have been made to properly assess the situation.
Okay, and after that process takes place, is there an effort to locate a firearm on the scene legally?
Correct. If you have the information that a firearm is on the scene, or there's a possibility that there may be a firearm on the scene, you may want to look for possibly sending the accused person to seek help, whether that's at the hospital, and depending on the call, whether it raises to the level of an involuntary hold on the person to the hospital, or if you can convince them to go voluntarily to the hospital. After that, if they decide not to go to the hospital and your hands are tied, I would start talking to them to possibly turn over the weapon for safekeeping.
Okay. If the person is taken to the hospital for mental health crisis care and a firearm cannot be located, and as I talked about earlier in the presentation, there is nobody there able to give you consent to search that residence, is part of your petition for the temporary extreme risk protection order an application for a search warrant?
Yes.
Okay.
Yeah, so you would make that application through the prosecutor's office. You would call them first. Hopefully, you try to obtain as much information about the weapon in question prior to making that call. Specifics, what type of firearm they may have. And you can do that through checks through the NCIC as well as any local firearm registries you may have.
Once the person is taken to a mental health facility or at least taken away from the residence, the police do not give that firearm back until what I talked about earlier, an extreme risk protection order hearing takes place, correct?
Correct.
Lieutenant Finan, are there situations where people other than family members have called the police and expressed some concern about someone acting maybe in a way that poses a threat to the safety of themselves or others?
Yeah, so personally, in my opinion, I think that's going to be the majority of the calls in references to TERPOs. Whether it be alarming social media posts by the accused, in which case, if a call ever comes to us in that situation, the officer or supervisor has to really investigate the credibility of the threat. At that point, a neighbor or a concerned citizen cannot apply for the TERPO themselves, the extreme risk protection order. In that case, the officer has to be the respondent to the TERPO. So they have to cover all their bases in their investigation as to whether the firearm is in their possession or they have the ability to get that firearm prior to taking this up to the prosecutor's office.
And let me ask you this: in your experience, we've worked on at least one together, and I know you've worked on others. This red flag law, this TERPO law, it seems to be the type of law that nobody has a problem with. Would you agree with that?
I would agree with that to a point. It's a common sense gun control is how a lot of people refer to this law. There are the concerns that maybe a neighbor is going to overstep their boundaries and say that this person shouldn't have a firearm, and that's when the officer needs to make a correct decision as to the validity of their claims and whether there is an actual threat.
Lieutenant Fine, I'd like to thank you for your time and joining me here. For our viewers, I'd just like you to know that on our website at acpo.org, there are many documents you can access in PDF, including the Attorney General guidelines on this subject, basically a summary of what was discussed today, and many other documents that may be helpful. And I want to thank you for tuning in. Thank you.